unmute us.
You too close?
Yeah, like it's a band.
There's something on the floor.
Yeah,
That's what
yes.
Some people phone Brian, is he coming in?
Othal Wallace, 2021-303-347. The defendant is present. For the record, if you don't mind saying your name on the record, so we have the record who's here.
Terry Shoemaker, representing Mr. Wallace.
Tim Probisco, representing Mr. Wallace.
Gary Wood, representing Mr. Wallace.
Jason Lewis, State of Florida.
All right, and then we are here at just a regularly scheduled status conference. Obviously, a couple of changes have happened in the last couple of days as far as the applicable law into this case. I don't think we'll be able to handle that or any aspect of that today. But I just wanted to address a couple of the things that have come up. Number one was a few motions that were filed. The main one being the motion for change of venue. If possible, I'd like to take that one up today. So it's the defense's motion. I already gave hints that I'm partial to the request, but if you don't mind making just a brief argument on behalf of the motion.
Your Honor, you know, and obviously we've spoken many times in chambers, and I don't know if Mr. Lewis hasn't been at all those, and we've been discussing the change in venue all along. You know, there's been so much media presence. You look around here today and you see it, and it's going to be, you know, probably front page news tomorrow morning and on the TV this afternoon. Obviously, the amount of publicity that's been out there, the amount of negative publicity towards Mr. Wallace is, you know, very, it's going to be very hard to see a jury that hasn't heard some sort of information about this. In addition, if you look at, you know, the GoFundMe page that we have talked about, you know, there's been thousands of people that have donated. If you take 3 degrees of separation, all of a sudden we have 6, 7, 8,000 people that are some way connected to donating money to the Raynor Fund, the GoFundMe page. And, you know, with all that going on, plus the nature of the, you know, Officer Raynor being a, you know, law enforcement officer and all that, the negative publicity, the number of people that have heard about it, the number of people that know about it, you know, I find it very difficult for us to be able to sit a fair and impartial jury in Volusia County.
Okay. Just on the narrow issue of whether or not we should change venue, that's all I need.
Yes, sir.
I read your response.
Yes, sir. So, I mean, basically my response, Judge, as you read, is the state would prefer to try and pick a jury here. We believe that the defense has not actually established the standard required by the Supreme Court in order for the court to rule yet without us selecting a jury, and they haven't provided enough. They put 2 affidavits from Mr. Probisco and their investigator, which isn't really a cross-section of the Volusia community, to establish that what they say, the Supreme Court, is ordinarily, absent in an extreme or unusual situation, the need to change venue should not be determined until an attempt to select a jury should be had. That's from Henyard v. State at 689 Southern 2nd, 239, Florida Supreme Court. We understand the court's concern, certainly, but we just feel like it should be an attempt to select here first. If the court does want to choose to move it, though, you've read our motion, sir.
Yeah, well, you know, you cited 3 cases at the end of your motion: McDuffie, Victorino, and
Toledo, yes, sir.
Toledo. I happen to have been involved in all 3 of them at some point or another. And I can tell you that with McDuffie, which didn't have nearly the publicity, we got a jury in Volusia County. But I want to say it took more than two weeks. I think it took about 3 weeks to get a jury. As I indicated to all the attorneys, we can spend here, and like I said, McDuffie didn't have the kind of publicity this case has had. Victorino 1 was change of venue, and Toledo was change of venue. So my inclination is not to, I don't want to waste time. And if we make an attempt at finding a jury in Volusia County, they'll be digging for diamonds. We'll have to go through 10 tons of coal to find one juror. And I think it might be easier just to go someplace else where the media will not be as prevalent or as forceful in terms of the message they're conveying out to the community, and then give Mr. Wallace a fair trial. So I'm going to go ahead and rule in favor of the defense and grant a motion for change of venue. Of course, that brings us now to the next step, is where. I noticed that you had picked 3 places. You suggested Broward County, Alachua County, and I can't remember the
Leon, Your Honor.
Leon County. Yeah, and I'm just curious how you came across. What compelled you to pick these particular places?
Well, Your Honor, and I think that since we filed the motion and doing a little more research, we would narrow it down to Alachua County. And the reason is if we look at the demographics of the population in Alachua County or St. Johns County, which the state has recommended, compared to Volusia County, Alachua County is more in line with the demographics. And like I put in my motion, if you look at the mean income, if you look at the percentage of African Americans within the county, if you look at the population, things like that, Alachua County is more demographically similar to Volusia County than St. Johns County is. And when we look at changing venue, we want to make sure that Mr. Wallace is able to have a jury of his peers picked, and I can tell you, when you look at a peer, it's somebody of the same standing. And having picked nearly 100 juries in St. Johns County, we're not going to get many people up there that are in Mr. Wallace's standing. So, and I think we could do that.
Well, let's just, let's get right to it. What is the definition of demographics that you think the court should follow? Is it simply race? Is it income? Is it political status? What exactly is it that you're looking for?
I think it's all those things combined. I don't think you can take one individual aspect and say, well, because there's fewer African Americans in St. Johns County, we shouldn't move it there, or there's the same number in Alachua, we should automatically move it there. I think you look at the whole picture and say, well, this area is similarly situated to Volusia County, and because we're going to have the same type of jurors, then we should move it there rather than someplace that we're not going to get the same type of jurors as we might in Volusia County.
Well, it's not that easy.
I understand that.
You looked at the census, which I did.
Yes.
Every county is just vastly different. I mean, there's some oddities,
Right.
There's some counties that have 20% or greater African Americans in them. Yet they're very affluent counties.
Right.
And you have all these varieties of data that is available in defining the word demographics that I'm not sure that I can ever find something, identical to what we have. Maybe something close, but it's going to be very difficult. That's just one component of what I have to deal with. Second component of what I have to deal with is whether or not that county can welcome this kind of a trial. Because many of these counties don't have sufficient court facilities. They don't have sufficient security. I've already been turned down by one county where I just made the inquiry. They're saying, no, we don't want you guys here.
Right.
Because they have construction issues and stuff like that. So there's a lot of factors in choosing. I guess I'm gonna have to justify ultimately where I choose to go. But anyway, what's this estate? I know you suggested St. Johns County. He's already shooting down St. Johns County.
Well, I don't think it's really the attorney's choice to choose, Judge. It's the court's decision. I've researched it. There's no appellate decision that says you have to find a racially or economically equal county. What the court says, and it just says, is you have to find a convenient county where a fair and impartial jury can be selected. So if you really want to break down to it, the defense has selected 3 heavily Democratic counties. And if you really look at it, if you looked at all the counties across Florida, if you want 2 that are very similar in economics and the African American makeup, Lake and Marion County, they have exactly around 10 to 11% African American community, and their socioeconomic amount is about the same as it would be in Volusia County. And that's what the defense is trying to correlate. But they mysteriously left those counties off there because they're trying to cherry pick what they feel would be beneficial for their case. We leave it up to the court to make that decision, but obviously we've used St. Johns County or Putnam County. Putnam County is outside the market of,
Yeah, not a court facility, but-
I understand, sir, but we've tried a death penalty case there before recently, and that was able to be accomplished. I'm just letting the court know, we don't believe it should be cherry-picked by the defense. We
No.
don't think that it should be picked to just accommodate based on these certain factors. I've never found a case, I looked through all of Westlaw, where they've ever overturned a court to the venue that they've moved it to. So certainly it's up to the court's pleasure, but we would encourage you to take a hard look at it, and if we can, keep it in the 7th Circuit.
Well, I like to justify where I'm going, you know, I understand they don't get to cherry pick any more than you get to cherry pick.
Yes, sir.
You know, Lake and Marion County served by the same media, you know, Central Florida media. I think Lake County is served by the same 3, I think it's 13, 6, 2, and 9.
But I think Marion is not a judge.
Okay, Ocala there, YCL, I don't know, I don't really know where the limits of the media is, whether Ocala is or not. It is,
We will cover Ocala and parts of Marion.
now you have to say your name.
Sorry, sir. Jason, Surgeon, Channel 9.
Okay, all right. Okay, so the media is shouting out here.
Yes, sir.
Sorry.
That they do maybe cover it. So I'll look into it. I don't want to be insensitive to try to be close, but at the end of the day, that may not be an available option. I want to warn you, I'm going to ex parte the state in speaking to one of the attorneys for the defense on a personal matter that could impact my decision, then I'll share that as need be.
Yes, sir.
But, so what I'll do is this, I'll try to start looking, well, the next step is about trial. Are we still on track?
Your Honor, we filed yesterday a motion to continue. The basis of that is largely predicated on the fact that we were here for a case management conference in February. It was just informally represented that we'd be receiving some new discovery. A few days later, we received probably the most significant of what would become several discovery disclosures since that case management conference. And the issue, to boil it down to as simply as possible, is we've received a significant amount of discovery. The most significant aspect is the disclosure of an internal investigations report as to some allegations of a false arrest committed by the decedent in this case. We filed a motion that we'll have heard on May 25th about the admissibility of that evidence. So that's among one of the things that we think there's further discovery, further litigation on. Additionally, there were doctors that were disclosed, approximately 1,000 pages of new medical records.
Is this post?
This is since the case management conference that we had in February 2023, Your Honor. Additionally, there were witnesses that the state seemed to, and again, I'm not saying bad faith or good faith or otherwise, the fact is this information came now. There were investigation that seemingly was initiated by the state attorney's office late in 2022. We gathered that it was into some phone records that the state had possessed for quite some time. They had looked into those. They traced back folks that Mr. Wallace had allegedly been speaking to right before and after the shooting. So now in March of 2023, we're faced with several witnesses who had contact with Mr. Wallace at or around the time of the shooting. That's significant to his state of mind. Also, there was, among those witnesses, even if they weren't around the same time, are purportedly going to establish some sort of alleged ties to some organizations that the state believes to be nefarious and impactful in this case. So all that to say, I mean, this isn't just, you know, a authenticating witness that we need to brush off. We've set depositions. In June on some of them, we've already had a cancellation. So I think this changes the landscape, Judge. I mean, when we were here in February, we announced ready for trial based upon the landscape that we perceived ahead. The landscape has changed. I think the intention or the good or bad faith is really irrelevant. We don't have any information to suggest anything other than, there was information that came to the state's attention and they followed up on it and they turned it over. So for now, we're just dealing with the fact that we have a significant amount of new information. A lot of it is very, very significant to our defense. We were aware that that information could exist. I'm not sure why we just received it in March. And the other issue that we're having is we still haven't received his personnel file. So we have a situation where in May, if the court is in a position to grant our motion, that could open the door to more investigation, more discovery. Certainly we're rolling down that path and gathering it now, but I don't think it would be prudent for us to say everything is the same as it was in February. So for that reason, we're asking the court to continue the trial. We're suggesting maybe a 2-month pass to October, but certainly that's where we stand. I spoke to Mr. Lewis beforehand. I don't believe he has an objection to it, but that would be our position, is that essentially the landscape has changed based upon the recent disclosure of new significant information. And we don't feel that we would have sufficient enough time to investigate those matters and litigate those matters prior to trial.
What's this say?
Judge, we don't object to like maybe a 1-month continuance. In response to the discovery, the defense had the phone records for the last 2 years. All we did is go down and contact people on the phone records and speak to them. So certainly they have their client availability. They could have talked to them to find out, hey, what did you say to this individual? So there's not a lot of merit to that argument. The medical records, all it's going to show is some injuries, and the doctors, that's not an overly complex issue to deal with. In response to the internal affairs file, I mean, saying that the state didn't get it to them sooner, that's a public record that any attorney could have requested 2 years ago. So we don't have a problem continuing it a month, but any assertion that we're holding back or we're doing things inappropriately is just not called for here, Judge. And a lot of the stuff the defense is saying that they want is things that they could have gotten on their own because they're public records, or as you've seen before, they've sent subpoenas to the court, and the court has allowed them to issue subpoenas for those items. So we don't have a problem continuing it a month, month and a half, 2 months if the court's pleasure, but we just want the defense to be on notice. This is a death penalty case. There's going to be continuing discovery coming out. We're not holding back things, but if we find things along the way, we're continuing to send them as soon as we can. Additionally, as they're aware, within 20 days of the start of the trial, we're going to get a whole bunch of stuff from them, and we're going to work diligently within those 3 weeks to get everything ready. That's how a death penalty case works, Judge.
Well, I can't very well find another place to have this trial without having some commitment that this is gonna happen. I can't call another county, say I'm coming in July, and then tell them, oh, I'm gonna change it to October. So,
And I think we've discussed, Judge, I don't anticipate there'll be a lot more stuff coming out, but obviously, if you want to put September or October, we don't have an issue with that. Obviously the sooner, I know time constraints for you, so if you wanted to set it in September, I think we can all be ready early September too, Judge.
I'll grant the motion only for a month. Set the trial to begin on September 5th, which is the day after Labor Day. And I'll start working on finding a place and then keep you informed as far as what I'm coming up with. So beginning September 5th, and then we'll run through until a conclusion. All right? You said we have another hearing coming up on the 25th?
Yes, sir.
Okay. Now, obviously, because of the change in the law, that may or may not be applicable in this case, you're gonna have to file your motions with respect to the change in the law, so we can address those before we get to trial as well, okay? Is there anything else we need to address today?
Nothing from the state, Judge.
Nothing from the defense, Your Honor.
All right, thank you very much. We'll be adjourned. Thank you. If everyone in the meeting today.
Too close.